Thank you, Amy. Lots of fun definitely describes this presentation. So thank you all for joining us today. I know that we're all crunching to get CLE done by the deadline. So if that's what you're here for, you're in the right place. There's a ton of great CLEs that are offered by the rest of our colleagues today. We know we're the last one of the day, so we know it's probably been a long day. We're thankful you're here. And our topic today is recent trends in copyright litigation. So as Amy mentioned, I'm Reid Mullen. I'm one of the partners here at the firm. Victor Chiu is with me, my fantastic co-presenter today, one of the associates here at the firm. And like most of the lawyers here, actually, Victor, we should go to our next slide, which will show our gleaming bios. Oop, I'm sorry, I'm controlling it. There we go. There we go. There we are. Victor and I, like most of the partners in the firm, sort of do a broad range of cases, but in particular, one area that we have a lot of experience, especially some recent experience, is in copyright cases. And copyright litigation has been recently and will continue to be a very active area of the law. And there's a lot of interesting developments, both in what I would call more of a traditional copyright case, books, movies, that sort of things, but also in software copyright cases, which have sort of exploded in the last decade or so. We expect to see more of that. And then, of course, we're all probably at least generally aware of the recent copyright litigation around generative AI and other forms of artificial intelligence. And those cases, too, are going to be very impactful going forward and certainly interesting from a copyright perspective. So what are we going to cover today? Well, we're going to cover a few different copyright doctrinal issues that we want to talk about, how those are developed in the case law. But we're going to do it kind of through the lens of looking at three types of cases here. The first is some recent cases in the land of audiovisual works. Victor's going to handle that for us. Then we're going to talk a little bit about computer software cases and what's been going on there and sort of how that is an interesting mix of traditional copyright doctrines applied to new and emerging technology. And then relatedly, the third area we're going to cover is artificial intelligence. Copyright litigation here is very active and also very new. So we're going to talk about a recent case in that area and maybe set the stage for what's likely to come in the next year or two. So with that, I think I will turn it over to Victor to get us started on some recent cases in the land of audiovisual works.
Thanks, Reid. So for audiovisual works, this is some of the more traditional or classic forms of asserted works in copyright litigation. Audiovisual works are recognized as potentially copyrightable subject matter under the Copyright Act. And one of the first cases we're going to look at will be the Disney hit Moana, which was recently the subject of a jury trial in the Central District of California. So as most people probably know, Moana was a huge commercial success when it came out. Around the world, it grossed close to $700 million at the box office and also won a Grammy Award. And it also had a very impressive cast, including Dwayne "The Rock" Johnson. And for folks who haven't seen Moana, the movie is set about 2,000 years ago and tells a story about Moana. And she's the daughter of a chief of an island. It's fictional, called Motunui. And before I go any further, I just want to note that the plot here is very relevant to what we'll be talking about today for copyright purposes. I'm not reciting it just because I like Moana.
I'll interject to say that's not entirely true. Victor loves Moana. I love Moana. If those of you who have young kids, you've probably seen it a gazillion times, and it's one kid's movie that never gets old for me. So that's my perspective as a copyright lawyer, Victor.
My daughter, who's 3 years old, will be watching this weekend too, just so she's up to date on her CLEs. So the general plot is in Moana, the island's crops start to fail, the fish disappear, and Moana learns that a demigod, Maui, and that's the guy next to her with the large hook, He's voiced by The Rock. She learns that Maui causes this blight on the island because he stole the heart of a land spirit named Te Fiti. So Moana's quest is going on an epic journey to find Maui and persuade him to return this heart to the land spirit, and that'll save the island from this terrible blight. So before we go into the copyright claim, let's just go with some of the basics of a copyright infringement claim. So Disney was sued for copyright infringement because a plaintiff claimed that Moana copied one of his works, and the plaintiff's name here is Buck Woodall. And so here's a brief refresher on what a copyright plaintiff needs to show if he's going to prevail on a copyright claim. So at a high level, they need to show 1, ownership of the copyright, and 2, the copying of protectable elements from the work. And the second element, it just means that not everything in a copyrighted work is necessarily protected by copyright, which means that can't be the basis of an infringement claim. And we'll get into some copyrightability issues later today. So how do you prove copying? Sometimes you can get proof of direct copying, and there might be the rare situation where you can get an admission from the defendant that he got a book and he copied verbatim paragraphs from the book. But usually this type of direct evidence of copying won't be available, so a plaintiff needs to rely on circumstantial evidence of copying. And that's where this model of jury instruction comes in. So if a plaintiff can prove by preponderance of the evidence that 1, the defendant had access to the copyrighted work, and 2, there are substantial similarities between the work and the accused work, that could be enough. So who's the plaintiff in this case? It's a guy named Buck Woodall, and he asserts that Moana copied his work called Bucky, Bucky the Wave Warrior. So Buck Woodall creates this animated film project over the course of a little over a decade. And he claims that Bucky was inspired by his experiences living in Hanalei Bay, Hawaii. And Bucky is about a teenager from New Mexico who learns that one of his favorite Hawaiian beaches is being threatened by commercial development. So he then travels through time to ancient Polynesia. He meets mythological figures there. He battles a shape-shifting demigod, and he solves a riddle from one of the volcano goddesses named Pele before he returns home a skilled surf hero that saves the day. And the allegations from Woodall's complaints were pretty striking when he first filed suit in LA. He alleged that his brother's wife's stepsister, named Jenny Marchick, quote unquote, masterminded a fraud by stealing all the components of what would eventually become Moana. And Woodall basically alleged that Marchick invited him to Disney's Burbank studio and asked him to pitch the Bucky work to her and other Disney executives. Now, there are some problems with this allegation that we learned during trial. One of them is that Marchick didn't actually work at Disney. She was working at the same lot, but in a totally different office. It was just a production company. And Woodall also alleges that Marchick signed a confidentiality agreement where he gave her the Bucky materials because he thought it was valuable intellectual property. But Disney later revealed during trial that Woodall actually forged Marchick's signature, and she never actually signed anything. So that probably made for some really good cross material at trial. So what did Buck think was actually copied from Moana? So the traditional, for a traditional copyright claim and for all copyright claims actually, to show substantial similarity, plaintiff needs to conduct a side-by-side comparison between the copyrighted work and the accused work. So on the left hand, you have Bucky, and on the right hand, you have Moana. So Woodall's complaint included a bunch of alleged similarities that he said proved substantial similarity. And this is one of the appendices that he attached to his complaint. One of the alleged similarities was, well, on the left-hand side, you have Bucky's volcano goddess, Pele, and that's from a trailer that he made. And then you compare that to the right to the goddess in Moana, and that's Te Fiti. And he said, look, they're both goddesses and they're both similar. Now, there's some visual differences here. Obviously, Disney noted that, look, the person on the left, she's not green. She's not covered by a bunch of foliage. Our person is. They're also two completely different goddesses. And here's another alleged similarity that Woodall included in his complaint. He said, on the left-hand side, look, there's Bucky. He's at a beach, and he doesn't have any parents on the beach. And if you compare that to the right, there's Moana as a baby, and she's at a beach, and she's also without parents. Again, this doesn't look all that similar to me, but that was included in the complaint.
Yeah, well, and I'll say, Victor, just as an aside, that the picture on the left of Bucky seems to look more similar to me to the Coppertone baby that's on the sunscreen bottle than to Moana, but I guess Coppertone wasn't part of the case. So here we are.
No, law defendants though in this case. And then here's another alleged similarity. He said, Mr. Woodall said, look, my story takes place in Hanalei Bay, Hanalei River in Hawaii, and the Motunui, the fictional island, is very similar. Again, I'm not too sure how many ways you can draw a river, but those were another one of those alleged similarities. So setting aside sort of these visual similarities that Woodall claimed appeared in both Bucky and Moana, he also suggested that there were other plot points that were similar and showed unlawful copying. So here's just a few tidbits from his complaint. He said, both Bucky and Moana involve a journey by the main character that starts with a turtle. They both incorporate the concept of sea navigation by the stars. And both of them also involve characters shapeshifting into bugs. So even though Bucky and Moana seem to have these pretty general similarities or similarities that are based on pretty common plot devices, this case actually ended up getting tried and it wasn't resolved on the pleadings or at summary judgment. So Disney did move for summary judgment, but the court actually denied it, a good chunk of it actually, because there was a dispute about whether Disney actually had access to Bucky. And that's where this interrogatory response actually played a pretty big role. This is from the court's summary judgment order, where the court said, well, there's a disputed fact as to whether Disney actually had access to and copied Bucky. And one of the interrogatories to Marchik, and that's the brother's wife's stepsister, the plaintiff asked, tell me any and all documents related to Bucky that you gave to any defendant, and the long list of defendants included Disney. So Marchik wrote, well, the only Bucky documents that I may have provided to any defendant was the Bucky material that I gave to a certain an individual at Disney TV Animation. And the court held that this was sufficient and that this matter had to go to trial. But Disney also advanced other arguments as summary judgment the court also denied Disney's motion for summary judgment that made other arguments. Those arguments didn't end up carrying the day. One of the issues that Disney made in its summary judgment motion was that the court should rule as a matter of law that Bucky and Moana were not substantially similar. And there were a lot of intuitive arguments there. Bucky traveled back to Hawaii in time to save a beach. There's no time travel in Moana. She traveled across an ocean to save the world. And there were also dueling expert reports by both there were dueling expert reports by the plaintiff and the defendant about whether there were substantial similarity. So the court said, well, you have these two experts who disagree about what's protectable and what's substantially similar. So let's let the jury figure that out. Disney also argued that its Moana work was independently created. It wasn't copied from Bucky. And in copyright law, independent creation is a total complete defense to copyright infringement. But the court said, well, this whole issue about access and independent creation are intertwined. So because access needs to go to the jury will also figure out whether the Moana work was independently created. The Bucky Moana case ended up getting tried in early March of this year. And according to reports, the jury returned a verdict that was actually less than the runtime of Moana. So it was a little fewer than 3 hours. And they found no infringement. And here is the special verdict form that they filled out. And for each iteration of Bucky that the plaintiff asserted, There's a 2003 version, a 2008 version, and a 2011 version. The jury found that Disney just didn't have access to any of these works, and therefore Disney didn't commit any copyright infringement. And there was plenty of strong evidence to that effect at trial. Marchik testified that she actually didn't give Bucky to anybody at Disney. She testified that she was an assistant at a production company and didn't have any ability to pass up materials along to Disney executives. The creators of Moana also testified, and they described their own independent development of Moana. They explained that Moana was inspired by Polynesian mythology and that they did their own research into the Pacific Islands. So given all this testimony and evidence about Woodall forging signatures, it wasn't totally surprising that the jury ended up finding that Disney just didn't have access to the Bucky work. So even though Disney ultimately prevailed on the access issue, there are a lot of copyright defenses that it asserted that were unaddressed. So they weren't addressed by the jury's verdict, and they weren't addressed by the court at summary judgment. And that was first, lack of substantial similarity. The second issue was the scope of copyrightable elements, and that's section 102B. And there's also the senza fair defense. So for substantial similarity, the jury didn't need to decide whether the two works were substantially similar because Disney didn't have access in the first instance. That basically meant that they concluded Disney didn't copy. For 102B, that was a trickier issue for the court to decide. And here is section 102B from the Copyright Act. So section 102B is one of the key doctrines in copyright law, and it provides that ideas, concepts, and principles aren't copyrightable. So Woodall's legal theories tried to claim copyright protection over a lot of ideas instead of creative expression. So Woodall's description of Bucky oftentimes veered into abstract concepts. For example, Woodall described Bucky as a, quote, a story about a teenager living in the contemporary moment who was chosen to travel across time to an ancient indigenous island in order to save it from imminent destruction. So that's a pretty general plot line that likely can't be the subject of copyright protection. There are also other things that Woodall asserted that probably wasn't entitled to copyright protection. He said that Bucky and Moana both featured elders who offered guidance to the main characters. But again, that's a pretty generic plot line, and that's existed for a long time and likely isn't eligible for copyright protection. And as another example, Woodall said that both Bucky and Moana were, quote, fun and friendly, high-spirited, and highly entertaining. But this, again, doesn't address expression. Those are just ideas, the concepts, the principles. So the court likely and probably would have found that these ideas weren't copyright protectable. There's also the issue of senza fair that the court and the jury didn't address. So senza fair is this doctrine in copyright law that basically says familiar stock scenes and themes that are staples of literature are not protected. And the core principle is that these standard or stock elements that exist in literature and movies can't be the basis of a copyright infringement claim. One of the Ninth Circuit has held as examples that if you tell a story about a dinosaur zoo, certain things will just be common to this dinosaur zoo. That includes electrified fences, automated tours, dinosaur nurseries, and uniform workers. Those are senza fair materials, and you can't assert a copyright claim based on those things. And sure enough, a lot of the elements that Woodall claimed Disney copied were probably senza fair. And some of the lists that they included were both Bucky's parents and Moana parents are substantially similar because they are, quote, risk averse and monitor the whereabouts of their children. And setting aside the fact that this is probably an idea, Disney argued in its summary judgment briefing, this is, quote, perhaps as generic and stereotypical a description of parents as one could imagine. Woodall also claimed that Moana echoed the main theme of Bucky, which is, quote, being true to yourself to find your destiny. Again, this is probably an unprotectable idea, but it's also a common theme, a stock theme that exists in all Disney movies and probably movies in general. So both 102B and senza fair were some of the big issues that the court ultimately didn't address. So given what happened in the Moana case, there seem to be two big key takeaways on the copyright litigation front. First, it's hard to win on substantial similarity grounds at summary judgment. And there's some Ninth Circuit authority here that basically says that summary judgment isn't favored when you're arguing lack of substantial similarity, because those are things that should go to the jury. And second, and this was the key part of Disney's success at trial, proving up access when you don't have evidence of direct copying can be critical. And if you can't tell a convincing story like Woodall did about how the defendant got access to the work, proving an infringement will be it'll be an uphill battle for you. And that's especially true given that Disney was able to put up the creators of Moana who explained how they developed Moana. So there was this, there's another case that happened about a year ago in the Southern District of New York involving Ed Sheeran that illustrates the importance of being able to tell an origin story. And this is true in a lot of IP cases in general. Marvin Gaye's estate sued Ed Sheeran for copying Let's Get It On through Ed Sheeran's Thinking Out Loud song. And on the stand, Ed Sheeran took out his guitar and just started explaining his creative process of coming up with Think Out Loud and just playing for the jury. And the jury found in a special verdict form that Sheeran independently developed or independently created Thinking Out Loud. So that just goes to show the importance of telling how you came up with the idea, how you developed it, and telling a good coherent narrative at trial. So that's a brief overview of some recent cases that happened in the audiovisual world. And as Reid noted, we're going to pivot now to computer software, which is also another pretty active area that's been the subject of debate in copyright law. So computer software occupies a kind of a strange space in copyright law. It can be copyrighted as a literary work, but the copyrightability of certain aspects of computer programs are often contested. So here's 102B again, but it also occupies a very important place in software litigation. So setting aside the fact that 102B precludes copyright protection for ideas, procedures, process systems, it also excludes methods of operation from copyright protection. And you can imagine that certain parts of a computer program are probably just a method of operation. So given that there's always been this tension in copyright law between the copyrightability of computer software and how that interacts with patent law. So if you think about it, computer programs are just a way for a user to cause something to happen at their direction. And software is this sort of fundamentally utilitarian thing. It's instrumental when you compare it to things like books, movies, or paintings. And there's been a lot of discussion among lawyers and academics about how copyright law should apply to computer software. But the basic tension is that if you give copyright protection to computer programs, copyright law might give computer software patent-like protections, which limits the public's ability to get certain tasks done efficiently. And so there's this famous quote from this Lotus development case in the First Circuit by Judge Boudin. And he basically says, applying copyright law to computer programs is like assembling a jigsaw puzzle whose pieces don't quite fit. So that brings us to this major, one of the major software copyright litigation cases that comes from the 90s and will have pretty big consequences for more modern software copyright litigation. So this is a Lotus 123 spreadsheet. Lotus Development Corp developed these programs. It was basically a software accounting program. And users could control the program through commands, which are part of the user interface. So there was a copy command that allowed users to copy things. There was a print command that allowed users to print things. And there's also a quit command. So users use the quit command, they would exit out of the program. So all these different commands could be arranged into menus and submenus for users to use when doing accounting work. So Lotus has this really famous program in the 90s, and one of its competitors, Borland, creates a copy of the menu tree that Lotus developed. And Borland didn't copy any of the source code. It just copied basically the words and the structures from the commands. And the purpose of the copying here was that users who are already familiar with the 1, 2, 3 program could switch to Borland, and they didn't need to learn how to use these new commands on Borland. They could just sort of reinvest their knowledge of Lotus commands and port it over when using the Borland software. So Lotus sues Borland for copyright infringement for copying the commands, and the dispute ends up in the First Circuit, where Borland says, wait a minute, you can't claim copyright protection over this. That's exactly what Section 102B prevents. And at this point in the 1990s, no circuit court had addressed whether these sort of computer commands that control software were copyrightable. So Lotus was one of those big cases that garnered a lot of attention. And the First Circuit evaluated Borland's argument, and it actually agreed with Borland and held that the menu command hierarchy menu wasn't copyrightable under Section 102B. And here are the two core holdings of Lotus. First thing, the First Circuit says, well, the commands are literally the means by which a person operates something, whether it's a car, a food processor, or a computer. It's a means to an end, it gets something done. So the copy command performs a copy function, the print command performs the print function. So that's not terribly surprising. And the second core holding was the fact that Lotus could have called these menu command hierarchy different things didn't make a difference. And it didn't change the fact that these menu command hierarchy was a method of operation. Lotus could have called the copy command something else, like duplicate or reproduce. That didn't matter. Because users operate Lotus by using the command hierarchy menu, and this menu was essential to using the Lotus program, the fact that these things could have been called something else was beside the point. And the Lotus court, the First Circuit, made this analogy to make the point that the command hierarchy was just a method of operation. In many ways, the Lotus menu command hierarchy is like the buttons used to control, say, a video cassette recorder. And it's just like the play buttons or the stop buttons on a VCR, which you can't copyright. So after the First Circuit came out with the Lotus opinion, the Lotus plaintiffs appealed. They filed a petition for cert. And the Supreme Court decided to grant cert on the issue of whether these commands were protectable under 102B. And the Supreme Court did a lot of work on this. It actually heard argument, but it didn't end up issuing an opinion. There was a 4-4 split, and which resulted in the First Circuit's opinion being affirmed because of the division. No opinion issued, and that's because one of the justices, Justice Stevens, recused himself because he held ownership of IBM stock, and by the 90s, IBM had acquired Lotus. So the First Circuit's Lotus Borland opinion ended up being affirmed, but there was no Supreme Court precedent deciding whether these commands were copyrightable in the first instance. So after the First Circuit's opinion in Lotus, copyright cases involving software interfaces were pretty rare. But we fast forward a couple of decades and we get to Google v. Oracle, where the Supreme Court finally discussed some interplay between the copyright claims and computer software. And I'll turn it now over to Reid, who had a very big role in Google v. Oracle.
Okay. All right. Google v. Oracle, the copyright case to end all copyright cases, or so some of us thought. Many of you, I'm sure, are very familiar with this case. Judge Alsup here in the Northern District called it the World Series of IP cases. It was a very noteworthy case and ended up resulting in 2 jury trials here in the Northern District, 2 appeals to the Federal Circuit, and 1 Supreme Court opinion that answers many questions, but also leaves many other questions unanswered. And it in large part does nothing to cure the gap left by the 4-4 affirmance in Lotus that doesn't leave us with a precedential Supreme Court opinion on what constitutes a method of operation under 102B of the Copyright Act. But in any event, let's talk a little bit about Google versus Oracle. I'll say as an aside, Keker, of course, handled the case in the trial court, and I worked on the case for a very long time. I always have a hard time calling it Google v. Oracle. It will always be Oracle v. Google to me because that's the way it came to us. Of course, as it ended up, Google was ultimately the petitioner in the Supreme Court, and that's what resulted in the opinion and the big precedent that we'll discuss in just a minute. But let's kind of start with the beginning. This case had everything from a copyright perspective. And to understand a little bit about what happened, it helps to kind of level set on what the case was actually about, because what it was about morphed a bit over time. It actually started out looking as a very big patent case in the early stages in the district court. By the time the case reached its first appeal in 2014, there were no longer any patent claims and no patent claims at issue in the retrial or in the Supreme Court. But let's talk a little bit about what the technology was. So the case, as many of you probably know, revolved around what are called the Java APIs. Java was a programming language originally invented by Sun Microsystems in the mid-90s. And when Oracle bought Sun in 2009, it took control of the Java programming language, the programming environment, and these APIs that are a part of the language and the environment that became the sort of fundamental issue in Oracle versus Google. So again, what is an API? Well, it sort of depends a little bit on who you ask. And there was dueling expert reports on this issue throughout the litigation. But since we're talking about what the Supreme Court did, we ought to at least look at the way the Supreme Court conceptualized what an API is. And here, what we're showing is a diagram actually from the Supreme Court opinion. This is from Appendix B of the majority opinion, authored by Justice Breyer, where he sets out in relatively clear short table what the API is, what this case is all about. And I think it's kind of helpful to first talk about what the case was not about. This part called implementing code at the bottom. The implementing code is source code that performs a particular function in the program. So what we're looking at here is a function for determining which of two numbers is greater. Both Google and Oracle wrote implementing code that would perform that function for a developer using either a Java product or using Android. That implementing code, there was no allegation by Oracle that any of that code had been copied. And the way the case was presented, there was essentially no dispute that implementing code, in that sense, would be copyrightable. But it wasn't at issue in the case because that's not what Google copied. Separately, there's what we're showing here on the left, which is called the method call. That's the language that a programmer who is using either Android or a Java program would physically type in to their computer in order to call up the implementing code that would perform the function of, in this case, choosing the larger of two numbers. And the point of having this relationship is that the developer can call that implementing code and get the benefit of having a program, a little mini program of sorts, that computes the larger of two numbers without actually having to write the program to create the larger of two numbers. So it's, in a sense, a little bit of a shortcut. And what the API does, and in particular this declaring code, is it's a connection point between the developer who enters a method call and the implementing code that will perform the actual function of returning the larger of the two numbers. The declaring code is what connects that and makes that all possible. That's what was at issue in the case. And as I mentioned, this is a diagram from the majority opinion. I think Justice Breyer did a pretty good job of explaining how this technology works. And I've actually heard a friend of mine saw Justice Breyer at a conference a while ago where he spoke and actually said that Oracle v. Google was one of his favorite cases because he really got to dig in and found it fascinating to learn this technology. So hats off to Justice Breyer for that. In the trial court, we didn't use that diagram, but we did use our trustee filing cabinet here. And from our perspective, one of the sort of themes that was presented in the trial court was the APIs are very similar in many respects to a file cabinet. They organize code within the program, code that was not copied by anybody, and they allow developers with an easy, efficient way to access that code. And Justice Breyer actually picked up on that analogy as well in the majority opinion. So I think the filing cabinet is both a helpful jury demonstrative and proved to be at least somewhat helpful for the Supreme Court in addressing that. Okay, so we talked a little bit about what the API is. Let's step back, talk a little bit about what happened in this case. I think we have to take it chronologically because it was a long case with many different twists and turns and touches on multiple doctrines, including copyrightability and fair use. Round one, and here we have a graphic of what I gather is two boxers. Kind of looks like one is rubbing the other one's stomach for some strange reason. So our graphics maybe aren't up to par here, but in any event, this is a boxing match. Round one, there's a jury trial in 2012 that addresses essentially two issues: infringement, whether Android was substantially similar to Java, and fair use, whether Google's use of the Java APIs in Android was a fair use. The jury actually hangs on the fair use question. They answer the first question on infringement, yes, Google's is at least use is a prima facie infringement, but they can't resolve the fair use question. The jury hangs 9-3. As the case was presented in the trial court, both sides agreed rightly that copyrightability, including an argument under section 102B, is an issue for the judge to decide, not the jury. So after a 3-week jury trial, the district court, Judge Alsup, issued a lengthy opinion holding that, in fact, the Java APIs were not copyrightable in the first place, in part because they were a method of operation under section 102B. And the district court opinion relies heavily on the Lotus case and numerous others to sort of build this argument from the ground up. After the case concludes, the Federal Circuit, or excuse me, Oracle goes up on appeal to the Federal Circuit. And that's because, of course, as I mentioned at the start, there were patent claims involved in the case at the start. I think there were 6 or 7 patents at the start. By the time of trial, there was only 2 patents left. Both of those patents were tried to a jury in another phase of a trifurcated trial. And the jury found no infringement of those patents. And those patents were not at issue on appeal, but because they were in the case at the start, they were jurisdiction was fixed in the Federal Circuit. So as presented to the Federal Circuit, there were essentially 2 issues. First, Oracle, the appellant in the case, argued that the district court had erred in finding that the Java APIs were not copyrightable. The second argument Oracle made, it was that the district court erred in denying Oracle's Rule 50B motion for judgment as a matter of law on fair use. So even though the jury hung, Oracle's argument was that the case never should have went to the jury on fair use in the first place because there was no disputed issue of fact on that. On question 1, the Federal Circuit reverses and finds that the Java APIs were in fact copyrightable. And in doing so, the court sort of directly confronts Lotus, and in particular, the definition of a method of operation that Victor mentioned. It comes from the Lotus case. The Federal Circuit essentially says, no, a method of operation must mean something other than the means by which somebody operates a computer program, because there are multiple ways to create the means by which somebody may operate a computer program. And because there are multiple ways, that must mean that it is protected expression and not a method of operation that would be excluded from protection under 102B. So the Federal Circuit reverses on that ground. The Federal Circuit also addresses Oracle's argument that the court erred in denying its Rule 50 motion. There, the court doesn't spend nearly as much time going over the evidence of fair use as it does on copyrightability, but addresses it rather briefly and concludes with this quote: "On balance, we find that due respect for the limit of our appellate function requires that we remand the fair use question for a new trial." So after the Federal Circuit ruled, Google petitioned for cert. At that stage, the Supreme Court denied the petition, and we go back to the district court for round 2, a jury trial on fair use. At that point, both sides are in agreement that it's up to the jury to resolve fair use. The case was tried to a jury in 2016, and the jury found unanimously fair use. After the end of the trial, Oracle again moves for JMAL under Rule 50, making essentially the same arguments that it had made before. Predictably, Judge Alsup denies the Rule 50 motion, and Oracle takes it up on appeal. Maybe not so predictably, the Federal Circuit this time reverses and says that fair use is a question that can be resolved, on this record at least, as a matter of law. And so that's round 2, fair use in the Federal Circuit. The Federal Circuit holds that fair use is a mixed question of law and fact, but the ultimate question of whether a use is fair or not is a legal question that gets de novo review on appeal. The court then goes on to analyze the evidence from the trial and concludes that Google's use was not a fair use as a matter of law. So at that point, the case is all but over, except for a petition for cert. And Google petitions for cert in 2019. The court this time grants cert on both questions: whether the Java APIs are copyrightable, including whether they constitute a method of operation under 102B, and the separate question of whether Google's use was a fair use. So I think many commentators watching this at the time felt like, aha, it is now time for the Supreme Court to answer the big question that they left unanswered by the 4-4 affirmance in Lotus. And that is, what is a method of operation? What does that term really mean under Section 102B as applied to computer software? Well, if you were one of those who was hoping for that sort of resolution from the Supreme Court, you didn't get it, because the Supreme Court did not address copyright ability at all. What the Supreme Court basically says, I have the quote in front of me here, is a holding for Google on either question, that is copyrightability or fair use, would dispense with Oracle's copyright claims. Given the rapidly changing technological, economic, and business-related circumstances, we believe we should not answer more than is necessary to resolve the parties' dispute. We shall assume, but purely for argument's sake, that the entire Sun Java API falls within the definition of what can be copyrighted. and we shall ask instead whether Google's use was a fair use. And the court goes on to conclude that it was. Now, before we get to the holding and what the Supreme Court said about fair use, I want to mention one other kind of procedural oddity about this case that in some ways at least harkens back to Lotus. The Supreme Court granted the cert petition in November of 2019. The case was set for argument in March, on March 24th of 2020. Well, as we all remember, something very big and surprising happened in the spring and late winter of 2020. COVID hits. The entire universe, including the federal courts, seemingly shut down. So a week before the March 24th, 2020 scheduled argument, the Supreme Court postpones the argument and indicates that it will be reset for the next term. As it happens, the case ultimately ends up getting argued in October of 2020 via Zoom, but it gets argued to an 8-member court because in between March of 2020 and October of 2020, of course, Justice Ginsburg passes away. And at the time the case is reset for argument, Justice Barrett has been nominated, but not yet confirmed. So we are again in the position of arguing the same 102B issue to a 8-member court with the potential, at least, for a 4-4 decision. As it happens, that's not the way it went. As I mentioned, the Supreme Court does not address copyrightability, pivots directly to fair use, and in a 6-2 opinion authored by Justice Breyer, the Supreme Court finds that all 4 statutory factors of fair use weigh in Google's favor. And of course, the ultimate question, therefore, weighs in Google's favor as well. And Justice Thomas issues a dissent with Justice Alito joining that dissent. But let's briefly, at a high level, talk a little bit about what the Supreme Court finds, and then we'll wrap up with just a few discussions of some of the more recent fair use cases as well. So those of you who know fair use know that there are 4 statutory factors that kind of guide and serve as the real heart of the inquiry. These factors are not exhaustive. And each fair use case seemingly presents its own unique facts, but every court is at least going to start with these 4 factors: the purpose and character of the use, the nature of the work, the amount and importance or substantiality of what you've used, and the effect on the market. And the Supreme Court marches through those factors in Oracle v. Google, but notably, although I'm starting with factor 1 here because that's the way it's listed in the statute, the Supreme Court actually starts with factor 2, which is what is the nature of the work at issue. And there, the Supreme Court has a relatively lengthy explanation of what the Java APIs are, and importantly, why they are different than the typical type of copyrighted work, like a book or a script for a play or a painting, and why they are different even from source code or implementing code that actually performs the function. And in the Supreme Court's view, the whole point of the declaring code was that it is meant to be used by developers who want to use these programs. And in the process of learning how to use a program, the developers learn how to call the methods that connect to this declaring code. And that, in the court's view, is related to interoperability and allows developers to reuse or repurpose, harkening back to Lotus, the knowledge that they have built up in using one program and to be able to port that over to another program. That's what these APIs facilitated, and that puts them very far from the core of copyright, if they're copyrightable at all. On the first factor, the court found that Google's use was highly transformative, even though in some sense it was using the APIs for a similar purpose to Oracle, in that it was making the functionality available to developers Google used it for a highly transformative product, the Android smartphone, that opened up a whole world of creativity that was very, very different than what was going on with Oracle's code. The Supreme Court also goes on to find that there was a very, very small amount of declaring code that was even at issue in the case. So the third factor weighed in Google's favor. And as to the fourth factor, the Supreme Court there too says that yes, well, it is true that Oracle could in theory suffer some sort of harm. The jury heard all sorts of evidence that in fact Android wasn't harming Oracle at all, and that Oracle had predicted a loss of revenues even before Android came out, and that the real value of these APIs was again not in their creativity as creative works, but rather in the fact that developers knew them and needed to be able to reuse them with new products. So the court finds fair use as a matter of law. And since then, this decision is relatively recent. You know, it's 2021 that the decision came out, April of 2021, I believe. And since then, we have started to see fair use cases percolate through the district courts and up through some circuit courts involving software. And we've seen direct application of Oracle v. Google and the effect that has on fair use cases in the software world. In particular, we're citing two cases here. Both of these cases resulted in a district court finding fair use at the summary judgment stage. The Teradyne case has now been affirmed in a memorandum opinion from the Ninth Circuit. Synopsys v. Real Intent is a case that our firm handled. It's currently still in the trial court, not yet on appeal, but there was a fair use finding as a matter of law at summary judgment. As to copyrightability, the Supreme Court doesn't really tell us much. That's not a question that was answered. So we still have sort of a rift between Lotus and the 2014 Federal Circuit opinion on copyrightability, as well as a few other cases that touch on this issue. So that's kind of an open area where we expect a lot more activity in copyright cases in the future. Now, we only have just a few minutes left, so we're going to be very brief here, but we couldn't not mention the Warhol case because that deals with fair use. I'm going to let Victor address that briefly, and then we'll give just kind of a preview of where we're going with AI cases.
Yeah. So right after Google, a couple of years later, Supreme Court issues its opinion in Andy Warhol Foundation versus Goldsmith. And just to quickly summarize the facts there, a photographer named Lynn Goldsmith took pictures of Prince, and that's one of her photographs is on the left. And she sues the Warhol Foundation because Warhol made images that made copies of her photograph on the left. And if you look at the right-hand side, those are the images that Warhol made. Now, Goldsmith was successful previously in licensing her photos to magazines, and Warhol had similar success. So Goldsmith sues Warhol Foundation for copyright infringement, and the Supreme Court decides one very narrow issue, which is just the first statutory fair use factor. And the opinion is long, but there are really just two core holdings from that case addressing the first statutory factor. And the Supreme Court holds that this factor actually tips in favor of Goldsmith. And the reason why is because both her photograph and the images that Warhol made, they have the same purpose. They're both portraits of Prince that are used in magazines to discuss stories about Prince. And the Supreme Court also holds that the Warhol Foundation's use is of a commercial nature because they licensed Warhol's images for money to magazines. So this was the most recent fair use opinion from the Supreme Court. And along with Google, it's being cited frequently in a lot of these fair use cases in copyright litigation. And we'll wrap up now with just a brief primer on artificial intelligence with Reid.
Yeah, so artificial intelligence, really, this is a primer because these cases are new. There's a whole bunch of copyright cases that have bubbled up in the artificial intelligence world, some dealing with what we call generative AI, others dealing with different types of AI. This is really a placeholder. I expect if we were giving the same presentation next year, there will be much to discuss here in the way of decisions on whether this type of using copyrighted works to train generative AI systems is a fair use or potentially implicates other areas of copyright law. There are literally dozens of cases now, many of which are pending here in the Northern District, others which are in the Southern District of New York. There's at least one or two in the District of Massachusetts. And those cases are, as I mentioned, in their infancy, but they will touch on many different areas of copyright law, but in particular, the fair use issues, to some extent, the issues that came up in Google and in the Warhol case. So we can move through these pretty quickly. I think by now all of us know generally what generative AI is and how it works. Can be an exceedingly useful and helpful tool for a whole bunch of things. And Victor, I think, is going to talk very briefly in our 2 minutes left about just one case that actually, I think Victor explicitly says it's not a generative AI case, but this is at least one instance in where we have a summary judgment opinion in an AI case. So tell us about it in 2 minutes, Victor.
No problem. I'll set my timer right now. So to make sure you all get out in time. There's this non-generative AI case, which the court mentioned a couple of times in its opinion, that resolved the fair use question in favor of the plaintiff. And this is the Thomson Reuters case that's going on in the District of Delaware. And nutshell summary is that this competing legal AI tool offered by Ross Intelligence essentially has copies of documents used to train its AI program, which are based on these head notes that we're all very familiar with. So if you look at this picture on your screen, that's actually from the summary judgment opinion. And the question on the left-hand side is what Ross Intelligence copied. And these questions are actually based on these West head notes. So if you look at the question on the left-hand side and the West head note on the right-hand side, those are the items in dispute. And the West head notes, of course, come from these case opinions. So the thing on the far right is a phrase from a Supreme Court opinion. So Ross copies these questions that are based on the West head notes. And the court tackles two questions about copyrightability and fair use. And just to speed ahead, the court holds that fair use doesn't favor the defendant. It believes that the use was commercial. It's not transformative because Ross and Westlaw both use head notes to create a legal research tool. And while he held that the work wasn't that creative because they're basically based on judicial opinions, and because the output didn't really contain the head notes, those two factors favored Ross. But ultimately, the court concluded that the Ross's AI tool was a market substitute, which had a big impact in that opinion, and held that Ross didn't show that there wasn't a potential market for AI training data. And therefore, on balance, all these four factors favored the plaintiff. And this case is going to might be appealed soon. The Ross moved for interlocutory appeal a couple of weeks ago. So it'll be up to the trial court to decide whether to certify the fair use question and whether the Third Circuit will actually hear the appeal.
So I'll say that's the end of our time here. But here's my plug. Join us next year when there will surely be a slew of district court opinions, at least addressing AI, and we'll have much to talk about then. But that's it for today. So thank you all for taking the time.